Good evening. Thank you all for coming. My name is Jan Dorner. I'm with the League of Women Voters of Elmhurst, and we'd like to start with some thank yous. Thank you to the staff and administration of Hadley Junior High and the administration of District 41. Thanks to all the volunteers from both the League of Women Voters of Glen Ellyn, especially Deb Hornell, and Elmhurst, especially Joanna Fernandez. Everyone did a terrific job putting this event together. Thanks also to Joe Piscatelli of Broadcast Production Services for recording this. Several months ago, the voter service group from the DuPage Leagues were discussing how important it was to know about judges and be able to vote informed. As Illinois residents, we know that we are not a battleground state. And although we all have strong feelings about the top of the ticket, we are beginning to realize how much more power we have down ballot. With that in mind, we have asked the Honorable Judge Bonnie Wheaton and the retired Honorable Judge Tom Dudgeon to speak to us about, among other things, what judges do and how they are rated. The Honorable Bonnie Wheaton is the Chief Judge of the 18th Judicial Circuit, DuPage County. She's been a judge for 36 years. She received a BA cum laude from Carleton College and a JD magna cum laude from Northern Illinois College of Law. She served in the traffic, misdemeanor, and law divisions and was presiding judge of the Chancery Division for 15 years. She was married to the late Ralph L. Wheaton III and has 2 children and 3 adult grandchildren. Retired Honorable Tom Dudgeon, a former associate judge of the 18th Judicial Circuit, has had a distinguished career in law and education. After earning his law degree from Drake University, he served as a trial attorney and later became a judge presiding over various court divisions in DuPage County. He was instrumental in developing nationally recognized programs in family law. Since retiring, he has taught constitutional law and American federal government at local universities. So let's start out tonight with Judge Bonnie Wheaton.
Thank you very much for having me. I'm delighted to talk about my favorite subject, judges. If you leave tonight, you will probably know more than 99% of the people in the state of Illinois about judges and how they are elected. It seems to be a closely guarded secret, but I want to tell you a little bit about judges, should I hold it like this? Okay. All right. How they get elected, or selected, or appointed. I hope I can do this. I am not a Mac person, and so if anything goes wrong, I'm going to call on Tom Dudgeon because he is a Mac person. So. See if I can get it going the right way. I'll start out in the very beginning. Wait a minute. It's not working. No, it's not moving. Uh-oh, what did I do? Oh, okay, all right. Okay. I told you I'm not a Mac person. Okay, in 1818, Illinois achieved statehood. And by 2022, there were 102 counties. Each county now has a county seat, and Wheaton, of course, is the county seat of DuPage, and it has a courthouse. Originally, each county did not have a courthouse, and in the days of Abraham Lincoln, the judges rode the circuit along with the attorneys. They would sort of have a traveling road show where the attorneys and the judge all went together from one place to another. And, oops. Tom? What am I doing? But that's not it's not full screen. Yeah. No, that's not. I want to go back. Okay. All right. I'm going to do it that way. All right. I want to make sure. And the first tier of courts that if you ever get into court, you will encounter are the trial courts. The state is divided into 25 circuits. As you can see from the different colors, some of the circuits are one county, like Cook County. Cook County is its own world, not only its own circuit. DuPage, Kane, McHenry, Lake, those are all single county circuits. LaSalle, Bureau, and Grundy are in the 13th Circuit, but way down in the bottom in the blue is the Second Circuit, and it has 12 counties. Every month I go to the Conference of Chief Judges and meet with the chief judges from all over the state. And I asked the chief judge of the 12th Circuit what the nearest town, the nearest big town was to him, and he said, Paducah, Kentucky. So I can't imagine having to deal with 12 county boards and 12 sheriffs. But if you've ever driven, of course, from Glen Ellyn to St. Louis, you know that there are lots of cornfields and very few people in the southern part of the state. And I'm going to try to work it this way. Okay, in the trial courts, that's where most of the cases are heard: traffic, misdemeanor, felony, divorce, tax appeals, all the other things that you can see up here. There are approximately 900 trial judges in Illinois, and there are two types of judges. There are associate judges. They are appointed by the circuit judges, and they are retained by a vote of the circuit judges every 4 years. It's very seldom that an associate judge is not retained, but it does happen. It happened just last June. The circuit judges, in turn, are elected by the voters, and those are the ones that you will see on your ballot if you're in an area where there is a vacancy. They vote for 6-year terms, or they are voted for 6-year terms, and they only have to vote in a contested election once. After that, they are voted on the ballot to be retained, and it just says, shall this judge be retained in office, yes or no? There are several judges, I believe, on the ballot this year who are voting who will be up for voting for retention, and it is very, very, very seldom that a circuit judge is not retained. We have had some very, very bad judges, especially in Cook County, who managed to get 60% of the vote. And it is 60, it's not 51%, it's 60% of the vote. And our mantra was sort of, well, if he can get retained, then we're not worried. But circuit judges and associate judges all hear the same type of case. And if you went into a traffic court or a chancery court, there's no way you would be able to tell whether the judge who is hearing your case is a circuit judge or an associate judge. They all hear the same cases. Let's see. Okay, what happens when you lose in the trial court? You can appeal your case to the appellate court. And the appellate court, this is not working, right? The appellate court has to take your appeal. And you appeal the case to the appellate court in the district where you are. Based on your circuit, you're assigned to a specific appellate court. And these, oh yeah, my chin, okay, all right. Oh, that's better, you're right, all right, I'll try that. Up until 2 years ago, in 2022, DuPage County was in the 2nd district, and you can see that by the heavy black line with the gray and the green. And that is because in 1970, when the judicial article went into effect, there were 5 appellate districts, except for Cook County, and the downstate 4 all had pretty much the same population. But in the 50-some years that passed, the population had gotten terribly skewed. So the 2nd district at that time had more than twice the number of judges who were in the 5th district, which is the heavy black line at the bottom of the state. Is that going off and on? It's on, okay. So in 2022, the legislature, in its wisdom, redistricted everything. So now the 2nd district is comprised of the bright green counties up on the top. And the 3rd district, we have been moved to the 3rd district, which is the brownish tan set of counties. So that is DuPage County, Will County, Kankakee, LaSalle, Grundy, I'm missing a couple. Bureau County. DuPage County has 48 or 49% of the people in the 3rd district. So it's very important to get out the vote in DuPage County. I think there are some, like LaSalle County and Bureau County, they may have, 20,000 voters, something like that. And it's very, very rural. But the Supreme Court districts are the same as the appellate districts. So who sits on the appellate court? There are, this slide says 54 appellate justices in the entire state, but I think there are a few more than that now, maybe 56, because with the advent of the Pretrial Fairness Act, the number of appeals just rose exponentially, and more appellate judges were needed in the downstate circuits, or districts rather. So there may be 56, but the 24 of those, still not working, 24 of those sit in Cook County, which is its own district, and the other 30 or 32 are in the other 4 districts. There are 7 in the 3rd district, which, as I said, covers DuPage, Will, Kankakee, Bureau, LaSalle, Iroquois, and Grundy. So how are they selected? Come on. All right. The Illinois Supreme Court sits in Springfield and sometimes in Chicago, and this is a picture of the Supreme Court building. I'll show you a picture of the Supreme Court, and you will notice that this is a very diverse group of people, and there are 5 women and 2 men. So Illinois has one of the largest percentages of women on the Supreme Court. And as you can see, there are 3 African-American judges and 4 Caucasian judges. So this is really something very, very revolutionary. Up until Marianne McMorrow was elected in, I think, in the late 70s, early 80s, they had all been old white men. So sorry guys. And Mary Kay O'Brien is our 3rd District Supreme Court Justice, and she was elected in 2022. I've gotten to know her very well, as I'm sure several other people in this room have, and she's absolutely a delightful person. She was on the 3rd District Appellate Court for 17 years and was a state legislator before that. So she really knows her way around not only the courts, but also around Springfield, and is a delightful, delightful person. Okay, the 3rd District Appellate Court is in Ottawa, and this is a beautiful, beautiful building. Except for the front steps, which I think are being renovated. They do have an elevator in there and a handicapped entrance, but it's right across the street from the park where Lincoln and Douglas had one of their famous debates. So, and this is the interior of the building. It's absolutely gorgeous. You can just imagine Abraham Lincoln arguing a case there. I'm not sure if he ever did, probably did though. And this is the historical DuPage County Courthouse. It was built in 1896, and it's in downtown Wheaton, and as you probably know, it's now condos. I always thought I'd like to have one near the bell tower when I retire, if I ever retire. But we moved out of that in 1991 into the new building out on County Farm Road. And I've been there since 1991, the day we moved in, so I can tell you a lot of the history of it. But since then, we've had some additions. The state's attorney probation building and the jail were all built out there in the county complex. And we are the envy of the state as far as what we have to work with. It's a good building to work in. It has its problems. We wish we had underground parking, but hey, can't have everything, I guess. So in DuPage County, we have 48 judges. Come on. There, okay. Right now, we only have 47 because there's a retirement, and we're in the process in the next couple of weeks of getting the 48th judge appointed. And these are circuit judges and associate judges, and as I said, if you walked into a courtroom, you would not be able to tell who was who as far as associate or circuit. There are some important quirks about Illinois judicial elections. When you get your ballot, you will see that, excuse me, the candidates run for a specific seat, the vacancy of Jane Doe. Like Karen Wilson just retired, so in 2 years, when someone runs for her spot, it will be the vacancy of Karen Wilson. Even if there are 5 judges on the ballot, each one will have people running for a specific seat. It isn't winner take all, it's just each specific seat. The candidates run in a partisan, Republican or Democratic primary election, and the winners of the primary then meet each other in the general election. There is also a possibility of running as an independent candidate. This is done very, very infrequently, although we do have an independent candidate now, and I will go on and tell you that in a few minutes. Judges are appointed to a vacancy, and they have to run to keep their position. We have, both on the appellate court and on the trial court, we have judges who have been appointed to vacancies, and they have to run and win in order to keep their jobs. We had one judge in the appellate court race who did not win the primary, and he will be out of a job come the first Monday in December. The legislature, in its wisdom, decided to turn the DuPage County courts into sub-circuits. When I ran originally, and when other judges have run in the past in DuPage County, we ran throughout the county. So we had to campaign everywhere from Wayne to Hinsdale. But now the judges will only run in one particular area. So there are going to be 3 judge vacancies on the ballot, but unless you live in that tiny sliver of Glen Ellyn between Geneva Road and St. Charles Road, or unless you live in, I think it's a very small area in Elmhurst, you're not going to see any trial court judges on the ballot. We have judges running in the 1st, 2nd, and 3rd sub-circuits, and they are very, very busy running just in those areas, but it makes it more manageable. You don't have to run in every parade in the county. You don't have to go to every township meeting, just the ones that are in your sub-circuit. But the quirks in this are, in the 1st sub-circuit, there were no associate judges who actually lived in the sub-circuit. And usually in the past, an associate judge would probably be appointed to fill a vacancy, but there were no associate judges living in that area. So I'm going to show you in a few minutes the candidates who are running both for Republican and Democratic and Independent in these areas. So this will be very interesting to watch because it's the first time that we've ever had this in DuPage County, although there have been sub-circuits in other counties as well. I believe that probably in the past there were the legislature decided that DuPage was such a Republican area that it didn't really make any difference. But now, as you know, DuPage is pretty purple. So it'll be interesting to watch and see what happens in this coming election. If you want to see your own ballot, you can Google the DuPage Election Commission and put in your address, and it will show you your particular ballot with all of the people that you have at your disposal to run for. And our mantra now is vote the whole ballot from the White House to the courthouse. The judges are always at the bottom of the ballot, and there's a tremendous fallout between the top of the ballot. Everybody wants to vote for president, but it falls off when you get to the bottom. So remember that, vote from the White House to the courthouse. And why should you vote, and why do judges matter? First of all, it's your duty as a citizen to vote. And democracy is on the line, especially in this election. I don't have to tell you about all the things that have happened in the past 4 to 6 years. But every case in the United States Supreme Court or in the Illinois State Supreme Court starts out in a trial court, either a federal trial court or a local trial court. And you probably read in the paper this morning about a federal decision that essentially allowed open carry of guns on public transportation. And that could very well end up in the U.S. Supreme Court. It'll certainly end up in the trial court. I was talking to Bob Berlin, the state's attorney, this afternoon, and he said the attorney general is filing an appeal. And I know the attorney who tried that case, and it'll be very interesting to watch. But that's why you have to be very careful about who you vote for, even in the trial court. And one of the other reasons that you should vote is that the circuit judges select the associate judges. If you buy me a drink sometime, I can tell you about the judicial politics in DuPage County and how lately, up until about a year ago, how associate judges were picked. But I can't say that on TV, I'm sorry. If you don't vote, you have absolutely no right to complain. You're the League of Women Voters and Friends, so I'm confident that you will vote. If you have children, grandchildren, make sure they're registered to vote. My granddaughter is in Denmark for the semester, and her parents are going to hand carry her ballot to her to make sure that she votes. So I have questions, but I'll wait until the end after Tom's presentation so we can take any questions from everybody. So thank you very much for your attention. Slight pause while he puts his on.
So we're gonna see how well this works.
Tom is a math person.
Thanks, no pressure there. By the way, my name is Tom Dudgeon. As you can see, I'm an old white man. My presentation is going to be a little bit different than Bonnie's. Mine's going to be a bit more esoteric, so try to stay awake. I think what judges do is often misunderstood by the public. And the importance of what judges do, I think, is likewise misunderstood by the public. When I used to teach American federal government, I would hand out a questionnaire to my students, and it was to get a baseline of their knowledge about our government system. And I always asked them, what are the 3 branches of government? And I'm not making this up. This is a very frequent answer. The frequent answer I would receive is Republicans, Democrats, and the president. Okay? You laugh, but these people vote. Okay? So the answer to the question is the legislative branch, the executive branch, and the judicial branch of government. We have 3 branches of government. In our system, each has a very different function, and it has a very different function by intention and by design. So if you understand that function, I think you'll know a bit more about why it's important to vote all the way down the ballot, as Bonnie suggests you should do. So let's see here. All right, so let's start really basically with what the purpose of government is. So if you really think about it, the purpose of government is to maintain stability and order in a society. When people get together, conflicts inevitably erupt. There has to be a means of resolving those disputes, and it has to be a means of resolving the dispute so that it ends. It's not any good if the dispute continues on. So the purpose of government is to solve problems that arise when human beings live together and form societies. And law is the mechanism for preserving order in a society. Think of the things that law does. Oh, we just went blank. There we go. Think of the things that law does. First of all, it provides a basis for human cooperation. If you drove here tonight, you used the highways, and the law created a mechanism for you to get here safely. You have to drive on a separate side of the road. You have to maintain the speed limit within reason. And you have to obey stop signs, traffic signals, stop for pedestrians. If you don't do those things and there's a police officer around, there are consequences. It also provides a common standard to resolve disputes. So let me just take a real simple example, the law of negligence. Negligence has a specific definition under the law. It's a failure to exercise ordinary care under the circumstances that causes injury to another person. So if there's going to be a trial, you as a juror have to decide, after having been given that definition by the court, whether there's been a failure of the party charged to exercise ordinary care in the operation of their motor vehicle. That's the same standard that's used in every single negligence case anywhere in the state of Illinois. It also defines the morals and sense of justice that's held by a society. The penalties, for example, that we impose for criminal activity are a measure of how we regard the level of activity that violates the standards of social decency. Law also regulates the power of government. There are things that you can and you cannot do as an elected official. There are limits. And we're going to talk about those just in a very generic sense here in just a moment. Now, if law is going to be a standard for regulating human behavior, both for individual citizens and for those who hold public office, that standard has to be a constant. Otherwise, it ceases to be a standard. If it cannot have multiple meanings, it cannot have variable meanings if it's to be an effective regulator of behavior. So there has to be some final authority to define what the law means. If you don't have that, then you threaten the stability and order within a society. It's going to quickly deteriorate. So who decides what the law means? Let me give you a very brief history lesson. You have to go back to Great Britain when much of our legal system originated. Government power in Great Britain prior to 1600 had finally begun to evolve into 3 branches of government. Prior to that time, it was pretty much the king. at least after William the Conqueror in 1066. It had evolved into an executive branch of government, and that was symbolized by the monarchy. Also a legislative branch symbolized by the parliament, and a system of courts, both the king's courts, which were called the law courts, because the king at one time before parliament made the law, and chancery courts, which were the courts of conscience, and they were often controlled by the head archbishop of England, who was often the chancellor, the chief advisor to the king. However, those three branches of government were not clearly separate branches of government. Members of one branch often served simultaneously in other branches of government, and the distinction between the monarchy and the English court system was particularly fuzzy. The law courts, as I mentioned, were called the king's courts. And so what the law meant was heavily dependent sometimes on the king for interpretation. Well, you can see the potential for mischief here. The law could be used to bend or be bent to serve the wishes of a single individual, in this case, whoever wore the crown or whoever favored the king. There was a French philosopher whose name was Montesquieu, who came to England in, I believe, the 17th century, and wrote a treatise on government. And he is the one who first advanced a complete separation of powers in government. And he argued that allowing the king to both define and enforce the law was a recipe for tyranny. And he argued that allowing the courts to independently, notice I've italicized and underlined that word, to interpret the law would act as a restraint on the limits of on the king's power. Let's jump ahead to 1780. I've picked this quotation for a number of reasons, not only for its content, but also for the date. I'm just going to read it to you. In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them, to the end that it may be a government of laws and not of men. Stated separately, we have three branches of government and everybody's supposed to stay in their own lane. Okay? The term Commonwealth is in this quotation because it's a reference to the first state constitution of the Commonwealth of Massachusetts, who was written by the person who this quote is attributed to, John Adams, who was the second president of the United States. Notice it is a quote from 1780. Do you remember what's going on in the United States in 1780? There's a little thing called the Revolutionary War. It is not over yet. There were colonial governments that existed prior to the time of the American Revolution. And you remember they declared themselves independent of England in 1776. So they were transitioning from being colonial governments under the control of Parliament and the King to their own independent governments, and so they began creating their own new state constitutions as states. Notice that the date of this quotation predates the creation of the United States Constitution by 7 years. This concept takes root in the United States Constitution and its drafting. And these are the first words of each of the three articles of the United States Constitution written in 1787. Notice, Article 1 says, all legislative power granted herein shall be vested in a Congress. Number 2, the executive power shall be vested in the President of the United States. Article 3, the judicial power shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. This is John Adams all over again, now at the federal constitutional level. Everybody stays in their own lane. Notice, legislatures do not have the power of deciding cases. Judges do not have the power of making law. Neither of them have the power of enforcing the law. State of Illinois' Constitution follows a similar pattern. Article 4 creates the General Assembly. The legislative power is vested in the General Assembly. Article 5 is the executive branch shall include a governor, lieutenant governor, secretary of state, comptroller, and treasurer, essentially creating the executive branch offices of state government. And Article 6, which is near and dear to Bonnie's heart and my heart, the judicial power is vested in the Supreme Court, appellate court, and circuit courts. And you remember Judge Wheaton's slide about the 3 different court levels that we have here, the circuit courts being the trial courts, the appeals courts being the first level of appeal, and the Supreme Court being the final arbiter of the law, or as we in the trial court often refer to them as, the court of final error. All right. So if the executive branch has the job of enforcing the law, think about what the executive branch must do. If your job is to enforce the law, you have to, of necessity, interpret what the law means. That's the first prerequisite to being able to enforce it. Well, how do we know whether the chief or executive's interpretation, whether it's the President of the United States or the governor, is correct in the interpretation? Should we leave the interpretation to the chief executive alone? Even between private citizens, the meaning of the law can often be in dispute, whose interpretation in such a dispute controls. Somebody's going to have the final say about what the law means. It was probably stated most eloquently by Chief Justice John Marshall of the United States Supreme Court in a case called Marbury versus Madison in 1803. And Marshall defines the role of the judicial branch of government this way. He says it's emphatically the province and the duty of the judicial department to say what the law is. That, he says, is the very essence of judicial duty. So we as judges get to define the meaning of the law. And our determination of what the law means, like it or not, folks, controls. That's how the system is structured. So what does it mean to say what the law is? Well, keep in mind that lawmaking is the function of the legislative branch under the doctrine of separation of powers. So we as judges do not make or rewrite laws. We are not given that power, and I hope the PowerPoints that show you about the separation of powers in our constitutional systems demonstrates that. So what is the law? In a democracy, the law is the will of the people, expressed through the actions of their elected representatives, whether they are in the Congress or in our General Assembly here in Illinois. And the will is expressed in the language used in the law, the very words that are put in print. So saying what the law means involves determining the will of the majority as expressed by the legislature by reading and interpreting the language that the legislature has used to say what the law is. When you are a judge, fidelity to the language of the law, what's written, not the politics of the moment, is critical when determining what the law means in a democracy. Our job is to say what the law means by reading it, and look what we're doing when we do that. Even if judges do not personally like what the law says or does, we cannot substitute our judgment for the language of the law. Notice how that process and that self-imposed rule upholds the democratic process. Our job is to define and say what the will of the majority was and what they meant. Even if we viscerally disagree with the law, and there are times when I've interpreted statutes, and I'm sure Bonnie can say the same thing, we might think that this is the dumbest idea on the planet, and we privately say that to one another in the corridor, but we have to follow what the law says. We don't substitute our judgment. You can see, therefore, why an independent judiciary is crucial to an impartial and uniform interpretation of the law in order to ensure that the democratic process is upheld. There are lots of people who like to influence is what I used to do and what Bonnie does and what everyone who wears a black robe does. People want the law to favor them. That's a natural human tendency. But it's an interesting thing when you walk into a courtroom. Do you want the judge to read the law in a way that favors your opponent? The answer, of course, is no. So if you don't want that, then maybe you shouldn't be asking for a judge to read the law that favors your reading. To make sure that the judicial branch of government remains independent, it has to be insulated from politics and from outside influence when it's going to say what the law means. So that's the only way, I think John Adams would argue, that you can have a government of laws and not of men. So what do I mean, and what do we mean when we say judicial independence? I think there's a great deal of confusion about this, because the phrase itself seems to suggest that judges are just kind of out there on their own and they're a bit untethered, and that's not what it intends to mean at all. The purpose of judicial independence is to create an atmosphere that ensures the fair and impartial adjudication of disputes. And to create that atmosphere, judges have to be independent of or free from certain influences when they do their work. So what are we talking about? Independent from what? Well, obviously things like bribery, but also threats, both direct and indirect. I don't want to die any more than anybody else does doing this job. And also from political influence. Independent from whom? First of all, the parties before the court. We cannot have what are called ex parte conversations with the parties, meaning private conversations that are not on the record with a litigant that's before us to talk about the case. We do not have conversations with other members of government who might want to pick up the phone and call and say, you know, Tom or Bonnie, this is a really important case for us, and we know that you, as a good judge who values his job, will want to decide the case our way because we know we're preferred. We also have to be independent of other judges. We don't go around the courthouse soliciting opinions about deciding cases. We make our own independent decisions on that, and we always say when we ever get judges together, it's a bit like herding cats because we're pretty independent cusses, particularly those of us who are at the trial court level. But that's good. It's intended to be that way. Obviously, we have to be free from outside interest groups and lobbyists who have their own agendas. And that also includes religious or political organizations. Judicial independence is central to why courts exist, because judges are assigned the task of resolving disputes in our society. How does judicial independence lead to a resolution of disputes in our society? Well, if courts are to resolve those disputes, those decisions have to be accepted by the parties involved as well as the larger society those decisions affect. To be accepted, those decisions have to be rendered fairly, but more importantly, and I have this highlighted and underlined here, perceived by the public and the particular litigants directly impacted by the decision as having been rendered fairly. Acceptance by the parties and the public requires impartiality to ensure that fairness, which is why all of those outside influences I mentioned have to be kept away from the court. Fairness, impartiality, and justice are all interrelated. Consider for a moment the types of disputes a judge is given to resolve and the power a judge has to resolve those disputes. Under the law, a judge has the power to do the following. This is a really dense slide for a reason. Award money damages for or against you. We can pick your pocket. Prevent you from acting. Interpret your rights under a contract. Determine who inherits your estate when you die. Divide your marital property during a divorce. Determine who has the custody of your children. Determine when and if you may see them. Take your children from you. Dissolve your business, sell its assets, evict you from your property, sell your home, force you to undergo mental health treatment, declare acts of the legislature or the executive branch of government null and void, grant or deny the government the right to search your home and your property, fine you, imprison you, and in some jurisdictions, execute you. Talk about an invasion of your privacy. Those are the powers that judges have. But it all goes back to that beginning set of slides, that esoteric stuff about the power of government and what government is for. It is there to resolve disputes that always occur whenever human beings gather together in a community and create a society. Stability of that society depends on a mechanism that is accepted by the public to resolve those disputes, because if the resolution by a court is not accepted, the society will fall apart. Now that sounds pretty strange. So let me tell you a very quick story to illustrate my point. Back in the day when the state of Illinois was flush with money, there was such a day, I used to frequently attend the National Judicial College in Reno, Nevada. Now when I always say that, people go, oh yeah, Reno, Nevada, now I know why you went. I don't gamble, I hate it. And if you had gone to this thing, you would wonder why in the world you would go, because every hour was regulated by the taking of attendance, and if you didn't have a good reason for not being there, you ended up paying for the trip out of your own pocket. So it was very intense, and it was really good education and learning. At the end of each program, they had a very brief graduation ceremony where you got your certificate that you could put on your wall in your chambers and impress people by how much learning you had. And one particular year, we had a judge who was a federal district court judge from the Southern District of Colorado as our speaker. And during the heady days of glasnost, those of you in the room may remember what glasnost was. It was that time of thawing of relations between the Soviet Union and the United States. The United States court system embarked on an exchange program with the Soviets and their court system. American judges were hosted by their Soviet counterparts in their homes, and then a few weeks later, the Americans reciprocated. Well, this particular judge had been on that program, and he was hosting his counterpart in Colorado over dinner one evening at his home. And the Soviet judge asked his American counterpart how many soldiers he had at his disposal to enforce his court orders. You laugh. So did we. Don't laugh. The judge answered, of course, I don't have any. Well, the Soviet judge was absolutely astounded by this. He put his fork down and he said, well, why do the people in the United States obey your orders? Think about that. Now it was the turn of the American judge to be astounded. And he answered the only way he could. He said, because they just do. If that makes our system of justice look fragile and insubstantial to you folks, it's because it is that fragile and that insubstantial. It depends upon you believing in and accepting the integrity and the impartiality of the judges who issue the decisions in all of those cases I just detailed for you, which occur every single day of every single American courtroom across this country. And people don't riot, they accept them. If you think about it, it is a social miracle. That's what's at stake when you get to the bottom of the ballot. If you think I overstate the case, by the way, find the Soviet Union for me on a map today. All right. So performing the acts I just talked about on that long list of cases involves the difficult business of doing justice. And the law sets parameters for us as judges within which we may act in the cases that come before us. But within the boundaries that the law sets, judges are granted discretion to fashion remedies in civil cases and to impose sentences in criminal cases. And the essence of judging is the exercise of judgment when fashioning a sentence or a remedy that is fair, so that it will be accepted by the parties involved and also by our larger society. Consequently, a judge's character, a judge's temperament, the experiences and the integrity of the person who wears that black robe are of utmost importance. Think about those kinds of cases I've listed for you and how individually affecting they are. So how do you go pick a judge? Well, first of all, judicial candidates cannot campaign on issues. They cannot take a stance and say, I'm tough on crime. Can't. I have a colleague that got in trouble with the Judicial Inquiry Board for doing exactly that. They cannot state how they would decide a particular issue. Why? As someone once said, facts make cases. You cannot foresee all of the crazy sets of facts that are going to come before you. And your job is to sit there and listen to the uniqueness of each case. Justice, if it's going to be justice at all, has to be individual. They cannot take political stands. You don't want to be thinking when you're walking out of a courtroom that a judge decided the case a particular way because you are a Republican or a Democrat or an independent. All judges as candidates can do is advertise their personal and professional experience and their legal credentials. Why all these restrictions? It goes back to the business of ensuring impartiality, both in reality and in appearance, so that the outcome of the case will be accepted. So people don't believe that it's tainted. So notice how this then creates difficulties for us as citizens when trying to decide who on the ballot we should vote for. Now that I've made it seem a bit inscrutable, let me give you a couple of pointers and then I'll be done. Here are some tools for educating yourself about judicial candidates. Bonnie's given you a list of the people who will be on your ballots and how to find the ballots that are out there for your particular portion of DuPage County. One of the places to go is the Illinois State Bar Association. I have the website up there for you to take a look at. Judicial candidates are evaluated. If you are a practicing attorney, you are given a questionnaire, a very extensive questionnaire, which you fill out. And if you've appeared in front of Judge X, who's running for a particular office, you are asked to comment on a variety of things concerning a candidate's health, knowledge of the law, experience, judicial temperament, and judicial independence and fairness. And the rankings are public for you to see and to read, and the Bar Association will then grade candidates on 3 bases: highly recommended, recommended, or not recommended. And you can look these recommendations of the Bar Association up in the results of the judicial polls of the attorneys who appear in front of these candidates who have been judges, and even lawyers who are running to be judges because they interact with other lawyers in their dealings. At this website of isba.org/judicial-elections/counties/DuPage. Everybody got that before I move on? Okay. There's also this website that I'm particularly fond of called Illinois Sunshine. Anybody heard of Illinois Sunshine? Okay, few people know what it is. All right, it's an independent site. All the data that it contains is drawn from the Illinois Board of Elections. And it lists all donors to judicial candidates' campaigns, including individuals, organizations, corporations, and political action committees. And what I like about this website is if you find a particular donor, you can click on that person's name and it'll cross-reference to who else that particular donor has made contributions. And you get some sort of an idea of who is backing a particular judicial candidate and perhaps why. Certain political action committees out there have judicial political agendas. They are interested in electing judges who think a certain way or interpret our Constitution in a certain fashion. There is a huge debate that's going on right now, created by the United States Supreme Court, between a new doctrine, I shouldn't say it's necessarily new, but it's the one that the court seems to be adopting, called originalism, which is very controversial. And I have to say that it's probably not a philosophy some other judges accept very well. And I think there's going to be a tug of war over this question. That is something for you to think about. If you don't know what the doctrine of originalism is, it works like this. It says, for example, that the meaning of the Constitution is freeze-frozen in the time when that particular section of the Constitution was ratified. So for the large Constitution prior to the amendments, that would be 1789. For each of the amendments, you'd have to look up and decide when the amendments were ratified. For the Bill of Rights, that would be 1790. I will give you an example of how the issue becomes a question for you to be concerned about. The word liberty is one of the words that appears in our Constitution, the federal Constitution. What does liberty mean? Does liberty mean the same thing it does today that it did in 1790? Or has it changed and evolved? If you're an originalist, you do not look at what it means today. If it has changed, you say liberty and the things that liberty consists of are defined by what it was in 1790. That's how the doctrine works. So be aware of that. Look at who is contributing to people's campaigns. And here is the website for you, IllinoisSunshine.org, real easy to remember. And you'll find that it's a pretty good interactive website to work on. All right. All of this involves work. Becoming knowledgeable about judges is not particularly easy because of the limitations on how they are able to campaign. But work's okay. Work is good. Democracy is not a spectator sport. I don't think I have to preach that given the fact that you're all here tonight. And keep in mind that democracy is not the will of the majority. It is the will of the majority that participates. So participate. Thank you.
Okay, we're going to do 2 quick questions because we're a little bit over, but wanted to make sure that you all know that we are nonpartisan, even though we have judges in the audience. You all know that. But do judges have a code of ethics to follow?
Yes, we certainly do. Oh, sorry. I have to go to the podium. We have the Code of Judicial Conduct, and that was recently revised to make it much more stringent on what judges can do and what they can't do. For instance, the code used to say that we could support or oppose any candidate as long as we were running. So when I was running for retention, that was considered to be, I was considered to be a candidate. So I could say who I was voting for the Supreme Court or for president or for anything else. That has been revised so that you can only, I'm not even sure what it is now, but it's much more stringent. You can only support or oppose another judicial candidate. Okay, John's nodding. And there are also a lot more strict restraints on what you can do in the community, in other political organizations, and in all aspects of your life. And I think that's a good thing. We want, I can't begin to tell you how much I enjoyed, excuse me, I enjoyed Tom's talk. But it's obviously very important on what we can do. Now, I think the U.S. Supreme Court is probably the only judicial branch that does not have a code of ethics or a code of conduct. And I think we're going to see that will probably change in the very near future. And I would, I agree. Okay. Tom, do you want to come up here too?
I'll just comment on why the Supreme Court does not have a canon of ethics. The Supreme Court is constitutionally created. It's independent of Congress. So if Congress passes a law that gives the Supreme Court a canon of ethics, it has, in my opinion, and I think that of other scholars, not that I'm one of those, but of constitutionality. It would be one branch of government controlling another branch of government. And I think that's the problem. There's a canon of ethics for the federal courts of appeals and the federal district courts that was created by the Congress because those courts were created by the Congress.
I did also want to add that along with Judge Dudgeon's, all of his links, the IllinoisVoterGuide.org has all the different bar associations, all their ratings listed on there for all the judges. So you don't have to remember all that crazy link. Just go to the IllinoisVoterGuide.org. Okay, so do you think election or appointment of justices a better system?
Thanks, Bonnie. It's an interesting question. You know, I was appointed, so I like that a heck of a lot. I didn't have to run. You know, I didn't have to do what these guys in the front row are having to do. It was pretty nice. The Illinois Constitution splits this because, as Bonnie's presentation showed, associate judges, such as I was, are appointed by the circuit court judges. And when I was at the National Judicial College, we often talked about how we got on the bench. When I explained that the theory in Illinois works like this: circuit judges are elected by you and I. They pick the associate judges. Theoretically, they know who's competent as a lawyer and who has the characteristics that would make a good judge, because we as lawyers appear in front of them every day. And so by giving it to the judges, it tends to depoliticize the process as opposed to leaving it in the hands of a political party. Because in the past, judicial appointments were often awarded for services rendered to a particular political party, but it was in power, and you got varying degrees of competency on the bench or incompetency on the bench. So that's the value of elections. It takes it out of the hands of politicians and puts it in your hands, but it requires a lot more work.
When I was, I should start out by saying every state has a different way of selecting judges. In most of the southern states, judges have to run every 4 years or every 6 years in a contested election. And that is brutal for the judges because they have to collect money to run, but it's also um, uh, antithetical to the idea of an independent judge. Because if a judge's rulings are going to be scrutinized and commented upon negatively, the judge, being a human being, is going to be very wary about what he or she decides. In those days when we were flush with cash in DuPage County and we got to go to Reno, I was talking to the wife of one of the speakers who came every year to conduct a class. And at that time, it was before I ran. I started out as an associate judge too, and before I ran, I asked her what she thought, because every year she came and saw judges who were appointed and judges who were elected, and she said she'd seen judges of all types for years and years and years, and she thought the only difference was that judges who had to run for office were more photogenic. So. But some places, I believe it's Massachusetts, where the governor has a blue ribbon committee who makes the appointments. Some judges, I think in California, they're appointed and then they have to run. It's all over the place. So Illinois, I think, is unique in the way that judges are selected here. I think it doesn't seem to make any difference. I think, I don't know, maybe having the name of the judge written on the wall of the temple would be one way to do it, but I'm not sure. But I don't know.
Okay, we could be here all night. We've got lots more questions. I'm going to do one more, and then that's it. So, do you think judges should be elected by political parties?
That's the perennial question. That's what we're stuck with here in Illinois, and I think the reason is if we had a separate election for judges where they just ran without a political designation, you'd have very, very few people voting. That's the problem. I would like to see that because I ran as a Republican. Now I consider myself a Democrat because I ran in 1990 or 92, I can't remember. No, 92, I think it was. And, you know, things have changed. It used to be that you could not get elected unless you ran as a Republican. So we had a lot of rhinos on the circuit court back then. Now I think it's sort of changed the other way, that we had one candidate in the second sub-circuit who actually wrote a letter to all of the previous bar presidents saying, I'm running as a Democrat because I can't get elected if I run as a Republican. So, you know, I would love to see nonpartisan elections, but I don't. This is what we're stuck with, and right now, as I said, Mary Kay O'Brien is in the process. Well, she did something absolutely revolutionary. She created a committee to, well, first she asked for applications for people who wanted to be appointed to the circuit court vacancy. I said Karen Wilson had retired. And none of in my 36 years on the bench, that has never happened before. And so they are in the process this week of doing their interviews, and they will make recommendations to her. Some of the people who applied to be appointed are Republicans, and some are Democrats. And I think, you know, I would rather have a friendly Republican than a Democrat who's unfriendly, even though I consider myself a Democrat now. It's a real problem, but I think this is what we're stuck with, and I think we're going to have it. And also, if you want to stick around, I think Tom and I will both answer any questions you want.
I don't really have much more to add to that, but I would agree that Justice O'Brien's approach to this is unique. It's refreshing. What we're really talking about here is when a circuit court vacancy or an appeals court vacancy occurs within a particular circuit or appellate district, it falls to the Supreme Court justice who is from those areas to do the appointment to fill out the vacancy term, and then that person has to run. That was always done. without the College of Cardinals, but just with the white smoke coming up the chimney, but without consultation, at least a public consultation.
Okay, thank you so much for all coming.